Hello everyone, my name is Marche Best and I am with the Office of Equity and Inclusion Professional Standards, and I'm here to give you an overview of civil rights, ethics, and professionalism. Our department is broken into two branches. The first is education and prevention, and the other is investigations and discipline. The goal of this session is to provide an overview of the issues regarding the following topics: civil rights, ethics, and professionalism. Before we begin, I'd like to start with a portion of the strategic plan for Duval County Public Schools. Now, the strategic plan can be found on our website. First is our way of work. We, as employees, are to provide educational excellence in every school, in every classroom, for every student, every single day. In our core values of Duval County Public Schools, our culture is built around these four pillars: trust, knowledge, compassion, and responsibility. Let's discuss our first topic, civil rights. The non-discrimination policy provides protections for certain groups and categories. This is in accordance with state and federal laws such as Title VI, 7, 9, and the ADAAA. The district has added several other protected categories, including sexual orientation, gender, gender identity, expression, etc. DCPS is a public institution, one that celebrates diversity and promotes equity. The following school board policies provide guidance about district expectations related to appropriate conduct in the workplace. These policies are modeled after state and federal civil rights laws. The equity policy addresses inequities in systems, policies, processes, and practices. This policy is intended to address any possible system inequities in areas such as hiring, curriculum development, and resource allocation, for example. The anti-bullying policy protects both students and staff from being targeted through written, verbal, nonverbal, physical behavior, electronic communication, or the use of technology by students or adults. Please note language in the legislation that uses the phrase severe and pervasive. A one-time incident that does not appear to be serious in nature may not constitute a violation of district policies or state and federal laws. Sexual harassment falls under the non-discrimination policy and is defined as speech or conduct that is sexual in nature, is unwanted or unsolicited, and is gender-based. It includes unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. There is a range of behavior that might be construed as sexual harassment in the context of your employment with the district. DCPS intends to create an inclusive and respectful work and learning environment and will address situations that may not rise to the threshold of a case brought to court. Cases reviewed by the district where discipline was deemed warranted include making sexual innuendos, requesting sexual favors, and unwanted touching. Employees who violate these policies may be subject to discipline up to and including termination. There are two forms of sexual harassment. You may have heard the term quid pro quo. Quid pro quo simply means this for that. An example of this would be where a person pressures another person to engage in a sexual or romantic relationship and then threatens her or him in some way, like telling them you will receive a bad evaluation. The second form of sexual harassment is called hostile work environment. This is created by the acts of one or more persons whose remarks or conduct are of a sexual nature, but are not necessarily directed towards one individual. For example, let's say there's a group of women who are speaking loudly and repeatedly about their sexual or intimate relationships in the lunchroom where men are also present and taking their break. If one of the men overhears the women's conversations, he may be able to file a complaint based on sexual harassment, hostile work environment, despite the fact that the women's comments were not directed towards him. Moving on to the next topic of religion, the school board's non-discrimination and harassment policy states that no individual may be discriminated against on the basis of their perceived or actual religion. There are guidelines which must be followed in an effort to ensure that the district and school staff do not impose personal views regarding religion on students or their colleagues. The following points provide guidance with regards to religion. Students may engage in voluntary individual prayer that is not coercive and does not substantially disrupt the school's education, mission, and activities. District and school staff may engage in activities that do not endorse one belief, practice, or tradition over another, or that promote religious coercion. Teachers may deliver information that teaches about religious holidays, but not information pertaining to celebrating religious holidays. Teaching about a holiday will be constitutional if it furthers a genuine secular purpose of education, is presented objectively, and does not have the effect of endorsing, advancing, or inhibiting religion. Please note that Title VII requires that individuals, including students, who require a reasonable accommodation for her or his religious beliefs need to be provided with accommodations, unless the accommodation would create an undue hardship on the conduct of business, in this case, the school system. However, district and school staff should never appear to endorse religion over non-religion or one particular faith over another. Organized prayer in the public school setting, whether in the classroom or at a school-sponsored event, is unconstitutional. The only type of prayer that is constitutionally permissible is private, voluntary student prayer that does not interfere with the school's educational mission. The points listed on this slide provide guidance regarding what is permitted related to religion. Please note that this list is not exhaustive. The principles of professional conduct also make reference to prohibitions against discrimination and harassment. District staff are bound by these principles as well as district policies. Please note that district policies, as shown on a previous slide, include additional protected categories such as sexual orientation, gender and gender identity expression, etc. With regard to the Americans with Disabilities Act Amendments Act, the district has a process for reviewing requests for accommodations under the act because of a disability. If employees are in need of accommodations, they will need to contact the Office of Equity and Inclusion Professional Standards so that they can request an application. Qualified applicants with disabilities are also able to request an accommodation during the application and interview process. Let's move on to our next topic, ethics. Ethics is a code of conduct governing proper professional behavior, which then establishes the nature of obligations owed to the individual and to society. In the case of district staff, to students, the profession, and the public. District and school staff should be aware that everyone has an ethical responsibility to the students, their parents or guardians, other staff, and to the community. Ethics applies to all district staff and extends to guests and volunteers while they're on school board property. Violation of ethics may lead to disciplinary actions and may even result in criminal or civil liability. As district employees, you must take an active role in reporting matters as they affect students, district staff, and school staff. Progressive discipline. If the employee engages in misconduct, then she or he is subject to progressive discipline. Progressive discipline is a four-step system utilized to reform undesired employee conduct and to promote adherence to the principles of professional conduct. Prior to administering progressive discipline, principals and supervisors may first seek to counsel the employee or give a verbal warning. A verbal warning is not discipline. A verbal warning is a tool used to inform an employee of performance or behaviors that might need to be corrected to avoid discipline. What you are looking at is a progressive discipline model for instructional staff. Step 1 is verbal reprimand. Step 2 is written reprimand. Step 3 is written reprimand and suspension without pay. And step 4 is termination. These percentages track misconduct in DCPS. The data reflects investigations for the 18-19 school year. The Principles of Professional Conduct provides 3 ethical principles: obligation to the public, obligation to the profession, and obligation to the students. With regards to the students, teachers assume physical contact with students is prohibited. Elementary age students, for example, especially tend to give hugs and show affection. While contact with students is permitted, educators should not touch students inappropriately, aggressively, or sexually. It is best to limit physical contact with students to high fives, handshakes, and fist bumps. When it comes to physical interactions, please remember to not hit or punch students, to not use physical force to discipline a student, to not throw objects at students, and to not solicit or engage in sexual conduct, a relationship of romantic nature, or lewd conduct with students. When it comes to verbal interactions, please remember that all communication between students and district staff must be respectful and professional at all times. Also remember to not discriminate against students on the basis of any of the protected categories. Do not use profanity towards the students. Do not demean, denigrate, or use racially derogatory terms directed towards or in the presence of students. The Student Code of Conduct governs student behavior and consequences related to violations of conduct. Refer to that code when addressing student behavior issues. Educators who are alleged to have touched a child inappropriately are subject to investigation by the Department of Children and Families, the Jacksonville Sheriff's Office, the District's Office of Equity and Inclusion Professional Standards, and the Florida Department of Education. The use of profanity is prohibited in district schools and work areas. Please be reminded again that district staff, particularly those who have direct contact with students, are held to a higher moral standard. District employees will subject themselves to discipline where evidence supports a violation of district policy, of state or federal law, and/or violation of the principles of professional conduct. Please remember that the district is an alcohol and drug-free workplace. School board policy states in part, no employee shall unlawfully possess, consume, or sell alcoholic beverages, or manufacture, distribute, dispense, possess, use, or be under the influence of, on the job or in the workplace, any intoxicating beverage or illegal mood or behavior modifying substance, narcotic, drug, amphetamine, barbiturate, marijuana, or any other controlled substance, as defined in the Controlled Substances Act, and as further defined by the regulations in Florida statutes, without a valid prescription. To summarize the policy, school board employees may not possess, consume, sell, or be under the influence of alcoholic beverages or drugs on the job or in the workplace. The workplace is not limited to the school building, but also includes off-site properties where school duties are performed, such as field trips, workshops, athletic events, etc. Please note that the discipline associated with this violation has been revised and provides for the following. First offense, 10-day suspension and mandatory referral to EAP for treatment. Employees may not return to work until the treatment plan is completed. The second offense is termination. Another obligation educators have to our students is to report suspected or known child abuse and neglect. Statistics show that per hour, over 350 children are abused. Child abuse does not discriminate. It occurs at every socioeconomic level, across ethnic and cultural lines, within all religions, and at all levels of education. Educators are mandatory reporters. Not only is it board policy, but it is also Florida law. The number to call is 1-800-96-ABUSE. You are required to give your name when you call. Your name will not be released as a reporter. Anyone who releases that information can be charged with the crime. However, sometimes parents guess who reported them. That's all it is, just a guess. If parents or students ask you if you reported them, tell them that you are not allowed to discuss the investigation. You are encouraged to notify your principal that you made the report so that when an investigator comes, the administration will not be blindsided. Please understand that it is your legal obligation to report the abuse. It is not the principal's obligation or the guidance counselor's obligation. In saying that, many teachers say that they have their students go to the guidance counselor after learning about the abuse. Please make sure that you are not having the child repeat his or her story to anyone else. If they talk to you about what's going on, please don't act shocked. Don't ask leading questions. You can ask, is there anything else you would like to tell me? You have a moral and legal obligation to report known or suspected child abuse or neglect to DCF. Your job is not to determine whether child abuse has occurred. It is not your responsibility to investigate or prove abuse. That is a job of DCF and law enforcement. If you suspect it, report it. A person who is required to report and who knowingly and willfully fails to do so, or who knowingly and willfully prevents another person from doing so, is guilty of a felony of the third degree. All educators have to complete a mandatory DCF training. Please follow the steps on the screen in order to access the mandatory DCF training. District employees may not provide tutoring services to students assigned to their school for payment unless it is a district-approved program for which the district pays the school employee. Tutoring for personal gain may also create a conflict of interest and could cause you to be less than objective when assigning grades. For example, if you are a band instructor and a parent asks you to give her son, a student in your class, trombone lessons, you can do this as long as you do not charge the parent or even the student a fee. Additionally, if the educator is offering private instruction for personal gain outside of school, he or she cannot utilize school board property without prior approval from the superintendent. Employees may engage in secondary employment. However, please consider your primary job when deciding on secondary employment. Secondary employment may be prohibited under the following circumstances. If the secondary employment impairs the independence in judgment or performance of school district duties. If there is an interest, financial or otherwise, direct or indirect, that substantially impacts the employee in his or her duties, and if the secondary employment violates the conflict of interest laws or provisions in the principles of professional conduct for the education profession in Florida. As we move on to our final topic of professionalism, please remember that as employees, we are to always display the highest degree of ethical conduct. We are, in fact, to model the behavior that we expect from our students. This includes, but is not limited to, maintaining proper attendance, being dependable, and having great time management, displaying professional behaviors and speech, having a positive attitude, and showing respect to students, other staff, and to the community. Although the district does not have a specific policy regarding attire, district staff are expected to wear professional clothing during work hours. The policy listed states that employees shall conform to the Student Appearance Code as a minimum standard. Generally, an employee's administrator determines what constitutes professional attire in his or her school or department. For individuals who are a part of a union, the collective bargaining agreement outlines the standards for professional attire. Professional attire is gender neutral and should reflect an individual's position, responsibilities, and duties. Your outfit can influence the way individuals interact with you at work and sets an example for others, most notably students. All district staff using district resources must adhere to the acceptable use policy. This policy states that district staff must act in a legal, ethical, responsible, and secure manner with respect to rights of others. District staff have an obligation to engage in ethical conduct as it relates to technology. Technology includes the use of email, social media, and/or cell phones. Per district policy, telephones shall not be used to make personal long-distance calls. Faxes cannot be sent at school board expense. School board policy also states that district communication equipment shall be used for the designated purposes and shall not be used for personal or non-school purposes. The use of social media can have far-reaching consequences for everyone, and these consequences may be positive or negative. While everyone has First Amendment rights, there are times when speech may not be protected and may have an adverse effect upon the academic and/or professional career of district staff. Employees should ensure that personal social media accounts are set to private. Friend requests should not be accepted from students or their parents. Discretion should be used when inviting colleagues to visit your pages. Employees should ensure that social media posts are respectful and that they do not contain profane, insensitive, or offensive language or images. Do not post photos or identifying language about your students, which is a violation of FERPA. As the slide indicates, district staff may engage in the use of social media through blogs and various social networking sites, but may not use office equipment and information resources for activities that are illegal, inappropriate, or offensive to fellow employees or the public. Employees may communicate with students in a professional manner using district computer resources, as it directly relates to their employment with the district. But employees should not solicit or engage in inappropriate communication with students verbally, in writing, or electronically, regardless of the age of the student. Employees are prohibited from engaging in any direct electronic communication with students, parents, supervisors, or co-workers, whether by email, instant messaging, or other digital media that adversely affects the employee's ability to perform his or her job. In addition, Employees should not expect privacy regarding the use of district computer resources. These include desktop computers and laptops, for example. Best practices to remember include, but are not limited to, the following. Number 1, do not post material that is illegal, sexually explicit, obscene, derogatory, related to alcohol or drug use, or in violation of copyright laws. Number 2, do not access social media networking sites from your school computer during work time. And number 3, be cautious about photos posted online. Please note that inappropriate use of social media could result in a violation of policy and could ultimately affect district staff's employment status. Please use your best judgment when using social media sites and understand the consequences they have. For instance, if a district employee attends a party where underage students are drinking and the picture is posted online, the employee may face consequences, including termination. The following list includes examples of ways district staff might be in violation of the social media policy. Some examples include sending text or email messages to students or colleagues that are inappropriate or unprofessional, posting or sending confidential information using social media or text in an unauthorized manner that does not warrant disclosure as required by law, using social media to leverage your position for personal gain or advantage with a student or with a colleague. District employees may participate in the political process. However, as public employees, please remember to be mindful of certain restrictions regarding personal political activities, as well as political activities related to the use of the district's property and/or the students. This slide highlights political activities that are not permitted. Please remember that district staff still has an obligation to be compliant with local, state, and federal rules while participating in the political process. To summarize, please remember that when engaging with students, the community, and members of the education profession, district staff members have an obligation to promote and exhibit ethical behavior at all times. If you are unsure what ethical behavior entails, just ask the following questions. Is the behavior or conduct that I'm engaging in unethical or illegal? Is this behavior a violation of district policies? Could my behavior result in loss or harm to students or members of the district? If the answer is yes to any of these questions, then do not engage in that behavior. Please remember that all district staff are expected to conduct themselves in the highest ethical manner at all times and to preserve public trust. Thank you so much for participating in this presentation. If you have any questions from the Office of Equity and Inclusion Professional Standards, you can just give us a call at 390-2181. Have a great day.